Justice, Mainstream and Cross Currents, Chapter 10, The Disposition, Plea Bargaining, Trial and Sentencing. This is a narrated version of this chapter PowerPoint presentation. The Disposition, Plea Bargaining, Trial and Sentencing. The criminal courts have several important decisional points that determine how justice is meted out, including plea bargaining, trial, and sentencing. Plea bargaining, not concerned with determining guilt or innocence, allows the defendant and the prosecution to efficiently determine the amount of punishment without the expense of a jury trial. The verdict plea, by pleading guilty or nolo contendere to a lesser included charge, the defendant can reduce the potential for a harsh sentence. A horizontal plea, the defendant will plead guilty to a charge in exchange for other charges being dropped. Reduced sentence plea. The prosecutor, defense attorney, and judge might decide on a reduced sentence. Avoidance of stigma plea. A defendant pleads guilty to a lesser charge in order to avoid a more serious charge that carries a stigma. Plea bargaining, some of the fundamental issues: presumption of factual guilt, costs and risk of trial, and what to do with the guilty. The trial includes the prosecution opening statement, defense opening statement, witnesses and evidence presentation, defense closing arguments, prosecution closing arguments, judge's instructions to jurors about procedure, judge's instructions to jurors about verdict, final verdict, defendant released if acquitted, or sentence if convicted. Figure 10.1, taken from your textbook, shows the criminal justice process. These are the basic steps of the criminal justice process. Note that not everyone who enters prison is paroled or released. Some offenders are incarcerated for life, where others may be sentenced to death. It starts with arrest, booking, prosecution files charges, grand jury, initial appearance, bail bond, plea bargaining, trial, sentencing, probation, appeal, prison, and parole. The pretrial phase of a trial. Motions can include motions for dismissal of charges, motion for continuance, motion for discovery, motion for severance of defendants, motion for severance of offenses, motion for the suppression of evidence, motion to determine competency, and motion for change of venue. Opening argument. The prosecution makes the first opening argument. No evidence is presented. The defense counters the prosecution outline of the case. Presentation of witnesses and evidence. The prosecution begins the presentation of case by introducing evidence and witnesses. Defense may cross-examine. Prosecution may redirect that examination. Defense may request recross-examination or direct verdict of acquittal. Defense presents evidence and witnesses, and then there's a summation. The case goes to the jury. Serving on a jury allows citizens to participate in the criminal justice system as a check and balance against government power. Steps of the jury selection involve a master jury list, voir dire. Voir dire is the defense attorney or prosecutors can attempt to exclude a juror by 1. Challenge for cause, or 2. Peremptory challenge. The case goes to the jury. Evidence. The prosecutor must base a case on evidence. The prosecutor must prove beyond a reasonable doubt the defendant is guilty. Classifications of evidence include real evidence, testimony, direct evidence, and indirect evidence. The defense doesn't rest. Reasonable doubt, defendant's testimony, alibis, affirmation defense, challenging scientific evidence. Rights and wrong in the courthouse. The rights enjoyed by defendants in the criminal trials are derived from the Constitution, specifically the Bill of Rights. Everybody needs to know their rights, and victims need to know and understand their rights. Under the idea of I know my rights, for offenders and accused offenders, they have the right to a speedy trial, a right to confront witnesses, a right against self-incrimination, a right against excessive bail, and a right to an impartial jury. Under victim's right, when a prosecutor charges a suspect with an offense, it is considered an offense against the state, even though there is more likely a human victim as well. Sentencing the offender, we have issues related to indeterminate sentencing, determinate sentencing, and mandatory minimum sentences. Figure 10.2, taken from your textbook, shows sentences of violent felonies convicted in state courts during 2006. You can see prison, jail, probation, and other listed in this pie chart. Figure 10.3, also taken from your textbook, shows the mean or average sentence length in state courts during 2006 for felons sentenced to prison, jail, and probation in months. Indeterminate sentencing. The parole board has the discretion to determine when the offender is ready for release, based on the medical model of corrections popular during the 1950s and 1960s. Indeterminate sentencing is based on 3 assumptions. 1, the offender is sick and prison staff can diagnose the problem. 2, the prison can treat the problem. And 3, the staff and parole board can determine if the inmate has been successfully treated. Determinate sentencing. Laws restricts the discretion of the criminal justice decision makers. The perceived advantage is uniformity. Presumptive sentencing allows judges some departure from the guidelines. Figure 10.2 is an example from the state of Utah of a sentencing guideline grid. This is available in your textbook, and it shows the score in the criminal history column on the left, tallied by the score each offense in an offender's criminal history. Therefore, an offender with little or no criminal history would have a score of 3 or less and be assigned to row 1. An offender with more prior offenses would collect more points and be placed in a higher row. The periods specified within each cell are typical length of incarceration if the offender is incarcerated. These periods do not apply if the offender is sentenced to an indeterminate sanction or to regular probation. Mandatory minimum sentences include weapons violations, repeated drunk driving, drug sales and drug kingpin laws, 3 strikes laws, and truth in sentencing. Questions we might ask after reading this chapter: what are the 4 types of plea bargains? What are the rights enjoyed by criminal defendants derived from? And what are some motions that may be made during the pretrial phase? This ends this narrated version of this PowerPoint presentation.